Mr. Ang Wei Neng.
Mr. Speaker, in Mandarin, please. 议长先生，刑事法临时条款法令顾名思义，本应该是暂时的条款。实际上，刑事法临时条款法令却一点都不暂时，因为它持续了63年。因此，有许多所谓的人权主义人士或组织都建议废除此法令。我在上一周就收到一封类似的电邮。然而，我不认为我们应该被这些人权组织左右。我们应该客观地探讨这法令的用处和弊病。未经审讯拘留的做法非新加坡独有。英国就在911恐怖袭击事件之后，推出了反恐保安法令，让政府有权逮捕涉嫌国际恐怖袭击的人士，在无需审讯或被法庭判罪之下，能够无限期的监禁。其次，据国际监狱研究中心的一项2014年的报告显示，全球共有多达250万的人士在未经审讯之前就被拘留，涉及的国家超过200多个，其中包括美国、英国、法国、丹麦、意大利等西方国家。换句话说，未经审讯拘留的做法，至今还是不适合完全废除，是有点可悲，有点无奈。不是我要为坏人说好话，既然刑事法临时条款的法令还是有它的用处，我们就有义务为那些未经审讯就被拘留的新加坡的人提供一定的保障。首先我想问部长，念智副是否察觉到现在的法治的社会新加坡，是否有越来越多人不肯在法庭上作证，或者是不愿意？第二，内政部是否考虑进一步的透露多少新加坡人，而不单是总人数，在此法令下被拘留？被拘留多久？有多少人是被反复拘留的？第三，内政部可否考虑加强刑事法令咨询委员会的职权、影响力和责任，并公开咨询委员会的名单，以增强透明度？议长先生，请让我用英语继续发表意见。Mr. Speaker, sir, we note that MHA has been judicious in exercising the power under the CLTPA. There were 1,260 detainees in 1988, and it dropped more than half 10 years later in 1998, 463. By 2008, the number has gone down to 290, and in 2013, MHA had kindly accepted my suggestion to publish a number of CLTP detainees and the type of criminal activities they were associated with on an annual basis. In 2013, the figure dropped to 200, and it has been dropping yearly since then and reaching a record low of 109, and in 2016 and 2017 is even lower. The declining number reflects what the former Home Affairs Minister, Mr. Wong Kan Sing, said in 2009, that CLTPA is only used as a last resort when a serious crime has been committed and a court prosecution is not possible because witnesses are not willing or afraid to testify in court. And a while ago, Mr. Shanmugam has also given the same assurance. As observed in the annual report of the Singapore Prison Service, SPS, between 2013 and 2016, the type of criminal activity associated with CLTPA detainees were mainly drug trafficking, secret societies, unlicensed money lending, and a few others. However, the current CTPL Amendment Bill, amongst others, adopted a fourth schedule where a sizable list of other crimes were also added. So I would like to clarify with the Minister whether MA has intention to use CL for crimes like murder, gang, rape, kidnapping, robbery, with firearms, and other organized crime. And if MHA has been observing that more and more witnesses are not willing or afraid to testify in open court. And what are the additional principles that will guide MHA to decide when to prosecute the accused person in court or dealt with under CLTPA? Taking the example of the high-profile murder of Kim Jong-nam in Kuala Lumpur, will this be an instant when CLTPA will be used rather than open court trial? I also note that under Section 28 of the CLTPA, the minister has the power to amend any schedule. And correct me if I'm wrong, the minister has also had the power to amend the new fourth schedule by notification in Gazette without going through the Parliament. And does MHA have planned to amend the fourth schedule from time to time? And for better accountability, could the minister consider providing an explanation and rationale as and when the fourth schedule is amended? In my early days in the Singapore Police Force, I had investigated a gang rape case involving teenagers, which would today fall under CLTPA if the bill is passed. There were challenges in gathering evidence, as some of the accused persons and witnesses went into hiding outside Singapore. Eventually, the case was resolved, and the culprits pleaded guilty in court. If they had been detained under CLTPA, the investigator would have an easier time. But it might have led to concern by the parents and others over the lack of transparency. According to the Singapore Prison Annual Report 2016, the number of detainees under CLTPA who were less than 21 years of age were 2 in 2016, 5 in 2015, and 7 in 2014. Given the declining birth rate in Singapore, each child is getting more precious. Hence, will the minister be able to clarify why was CLTPA used against such youth rather than charging them in court? Do these youth have the means, influence, and connection to intimidate the witnesses? And I applaud the minister's decision to appoint a sitting judge as the chairman of the advisory committee. This enhances the standing of the advisory committees. However, the process is also important. Could the minister elaborate more on the process of the hearing by the advisory committee? If a detainee cannot afford to hire a lawyer to defend himself, would MHA consider assigning him a defending lawyer? Yesterday, minister said that even a child rapist is entitled to his day in court and to be defended. So what more can we deny a CLTP detainee a lawyer just because he could not afford to pay? Can the family members attend the hearing? How long does it take for the detainee and family members to be informed of the outcome of the hearing? I understand from a family member of the detainee that they may take up to 6 months before the hearing is made known to them. It's a pretty long period given the order is 12 months. In addition, will MHA consider publishing the names of the esteemed advisory committee members for better transparency? In order for Singaporeans to trust the CLTPA processes and legalities, it is important that the Singaporeans are kept well informed. The CLTPA is a tool which has clearly helped us to ensure the safety, peace, and security of Singapore over the years. This 5-year parliamentary review is a check and balance for us to periodically ask ourselves if the Act is still relevant, and I support the extension of the CLTPA for another 5 years. However, it is necessary for us to reassure Singaporeans that safeguards are in place, that the amended CLTP Act is not abused. With this, I support the bill.